Alex here with a high conflict child custody video on ulterior discretion. I'm kind of mixing two principles. The discretion that a judge can use, and I've stolen half of the phrase or the pair of wordings, ulterior motives. And I have gotten this question before, not very often, but I can tell that the people who ask this question have really thought it through, as I do personally think that this is a thing mostly in family court, and it's interesting to see more and more people starting to call it into question. And the main issue is viewers trying to find out what they can do about it. So, yes, the judges have a certain amount of discretion in any courtroom. In family court, I think most of us know, and even in the case law, it says that the family court judges are afforded what they call wide latitude or an extraordinary amount of discretion. And I don't know how it got this way. It's just the way it is. And the reason that I think it happens mostly in family court has to do with the culture of family court, and also because they have so much discretion. So when you have a whole lot of a particular thing, that's what you're going to see is used to game the system. So, what exactly is the question that's being asked? The question is, hey, Alex, what if there's a particular thing that the judge does not like that I'm doing or did do or I'm accused of having done? And that particular thing isn't illegal. And if the judge based their decision on that particular thing, it would be an abuse of discretion and get overturned. However, what the judge did, or at least they accuse the judge of having done or suspect the judge did, was to really not mention anything at all about that particular thing that they did, and instead use the other sort of areas of analysis, the best interest factors and stuff like that, to come to the conclusion that they wanted to reach for the actual thing that troubled or disturbed or upset the judge. I think the easiest example here is guns, Second Amendment, and that's just because I think that it comes up every now and then in some of these cases, and I think it stands out as one of those especially dangerous things for a judge to cite in their order, and at the same time, one of the especially dangerous things to become an issue in family court. So, for example, most a common question might be, hey, this particular parent shows up at a child exchange with a gun on their hip, and it's it's scared the judge. But at the same time, if the judge puts in their court order that they're taking custody from that parent because they had a gun, the judge and the parent knows that that's going to be a can of worms. It's going to go to it could go up on appeal, and they could say, hey, this is my Second Amendment right. I shouldn't have lost custody over exercising that. It could end up in the news with, like, I don't know, an NRA pro-gun group. Hey, this family court judge takes custody of people who have guns. This is a very obvious issue of something that could upset a judge in family court, because they might feel like the gun is being used in an exchange for intimidation, or that it could for some reason somehow get used and the parents or the child get shot and killed. Like, there's a lot of scary things with some, not all, some family court judges, where it could come up, and it makes it a very dangerous thing for that judge to base their decision on. So what are they going to do? And I'm not saying that this happens for sure, though I do suspect it does. I do very much suspect it does happen, where the judge is like, okay, this person shouldn't have custody because I really don't like what they're doing, and all these other bad things can happen, but I can't put that in the order. So what I'm going to do is I'm going to go through the best interest factors, and I'm going to find out some of the areas where if I use that against the parent who had the gun, it would be plausible and supported by substantial evidence, and then if it was appealed, I should be okay. So this is really going back to the title, which is Ulterior Discretion. The judges exercising their discretion in a way that is safe and legal and won't get them overturned on appeal, and probably won't get them attacked by a guns rights group, while at the same time is not actually the reason that they did anything. It's not the actual reason that they placed custody with the other person. They just put that in their court order to make it so that it would be upheld on appeal and they wouldn't get attacked politically. And so they ended up reaching the conclusion that they wanted to reach in a way that was very safe for them to reach. People are like, hey, does this happen? 100% for sure, I don't know. My gut feeling is it probably does, especially with the older judges. In Nevada, the newer judges are different. There's even a lot of them that are outsiders. I would call them outsiders. They're not really part of the clique or the club, and so maybe it's not as much of an issue with them. But the ones from before, they were very much the sort of judges, in my opinion, that would follow the sort of belief of the ends justify the means. And if they're protecting the child, then who cares what's in the court order? That's sort of something that I do very strongly suspect has and does occur. But really, you can't do anything about it. Sorry, guys, you just can't. What are you going to do? Hey, there's a conspiracy to take away my rights for using, Second Amendment, and all these reasons that they put in there aren't real. It's not going to work because the appellate court's going to go through the record and they're going to say, here's the things that the judge says they base their decision on, and here's some testimony from your ex or a certain document or a photo or it's supported by substantial evidence. And since they went through the factors and the factors are supported by substantial evidence, they're going to uphold the decision. Sure, there's a gun, and that was a crazy issue that came up, but the judge didn't cite it. In fact, the judge might even put in the court order that it was troubling, but that's not what they based their decision on when it really was. You can't do anything about it, guys. You just can't. So what does that tell you? You could be principled and lose your custody, or it sucks. It sucks, but you could be principled and end up losing, or you can not do stuff that looks really bad, even if it's not fair. You might feel like it's not fair. You might feel like it's not American. You might feel like it's not an ideological world. Oh, well, it's not. It's not any of those things out here in this world. So if you're concerned that taking a gun to an exchange, and this is just like, guys, there's a lot of examples of this. This is just the most obvious example because I think people can very quickly come to the conclusion that I'm coming to, which is, yes, that scares a judge, but they're not going to put it in the court order. If you don't want that to happen to you, you have to figure out another way to deal with the problem of self-defense or protecting yourself or exercising your rights that's not going to implicate your custody rights in a family court case. I guess that's all I have to say on this issue. It's a very real issue, and there is no way to fix it. If it happens to you, you can try and appeal if you really want to, but if I was you, I would not go with the conspiracy theory approach, and I would be critical of the best interest findings that the judge relied upon. Cross your fingers and hope that maybe somehow they made some kind of other mistake. But even if you get it overturned on appeal, you'll probably end up in front of the same judge, and they'll probably find another way to make the same decision. So this is just one of the ugly, ugly realities of family court in our modern society. If you guys feel this happened to you, put down in the comments below, especially if it wasn't a gun issue. Maybe spanking. That's one of them, guys. If a judge takes away your custodial rights because you spanked your child, that's going to open up a can of worms too. And maybe they think that you shouldn't have the child, but they don't mention that in the order. Instead of mentioning the spanking issue that they actually believe is what's going to make them take your rights away, they mention a whole bunch of the other best interest factors. And, I don't know, they could say you're not communicating to meet the needs, or that you're the parent least likely to facilitate contact. Stuff that's really a minor issue in your case, but they make it into a bigger issue in that final written order, so that if you appeal it, they're upheld. Spanking. So there's probably other stuff out there that I haven't thought of, guys. I don't know, maybe some of the vaccine stuff. It's another can of worms. You have the right to choose and stuff. Judges like, I'm just not going to deal with the vaccine stuff. I'll find some other basis to take away their custodial rights. Okay, so the last thing I guess I'll say is, do I think it's very often? No. If I was to list the judges on a piece of paper that I thought might have done it, it might be half. Maybe half of them might do it. And I don't know. Maybe they saved a child by breaking the rules. I don't know. I don't want to get into this discussion. All I want to say is I do think it probably happens sometimes, and I do think that there's probably nothing you can do about it. So maybe the best thing that anyone watching this video can do is, if they feel like this personally was an issue in their own case, they can mention it down in the comments below to give people some perspective on some of the things to sort of avoid in your child custody case. One last thing that I'm going to mention is you may not even lose custody. It may just end up dragging things out. You may end up in a situation where the judge is very disturbed about something that you did that is legal, but you probably shouldn't have done. And so maybe they don't take away your visitation rights or your custody rights, but maybe just to make sure that everything's okay, they stretch your case out for a year or a year and a half or 2 years, or you end up going through supervised visitation, or you end up with some temporary orders that are disfavorable to you, stuff like that. And then in the end, you may be okay, you may be cleared, but you ended up not seeing your kid that much for a couple of years. That's probably something that even is more likely to occur, because how are you going to appeal if you don't have a final order? Temporary orders are very difficult to challenge. I talk about that in the video, temporary orders. All right, guys, if you have any questions, again, feel free to post them down in the comments below, and I will see you guys next time.